Okay, firstly, hi everyone. This is the third iteration of Meet the Experts. For those of you who don't know me, I'm Stuart Suskin. I'm a private mediator with a statewide practice. And before we get started on this program, let me give you a little bit of background on the genesis of how we got started and where we're going with this. For those that missed the inaugural meeting with Ray Malka, George Kagan, and former Judge uh, Steve Rosen on our initial program, where we talked about this. This was a conversation that I had with Deputy Chief Judge Dave Langham. I called to grouse about something, which is, I guess, a nice way of saying bitching and moaning. I'm his favorite curmudgeon, and I called to voice my displeasure with the Florida bar over the fact that, in my view, many of the really valuable programs that attorneys and claims professionals would love to attend are beyond their economic ability to pay for. If you're a young associate, if you're in a small firm, and a mediator of any kind, private, state, and you're not being reimbursed, you're likely going to limit the programs that you can attend from a financial standpoint. And so that was my first concern is how do we make this, how do we make these programs more affordable? Then I got onto another pet peeve where we have some great programs, the forum, the workers' comp convention, the lunch and learns, but many of those concentrate on case law, rules, statutes, professionalism, ethics, but not so much on the how-to. Now, we have the trial advocacy program, which is outstanding, but again, for many, it's not affordable, and of course, the registration is limited. So I voiced these concerns to the judge, and he said, "Stuart, do something about it." And I said, "What?" He said, "Don't just talk about it, do something." And I said, "Yeah, Judge, I'm just a mortal. I'm a private mediator. I'm a nobody. How in the world could I do something about this?" And he said, "I'll help you." And that was the beginning of this kind of partnership. And the judge just ran with it. And I have to, give approbation to him because he takes each of these programs, he prepares outlines in order to get CLE credit for you guys. He takes over with bios. He does the blasts for the invitations. So you all know about these programs. He handles all the infrastructure as far as technology to make these programs available to all of us. Uh, Without Dave Langham, this just doesn't happen. So, a special thanks to him. Thanks to all of the terrific speakers. We started off with Ray Malka, George Kagan, and Steve Rosen, where they addressed things that they learned and the good way and the hard way over the past 50 years. The second program dealt with the uh, day-to-day practice uh, procedures for attorneys on both sides of the aisle. That was put on by Glenn Whelan, Dawn Traverso, and Brian Greenberg. Today we are dealing with adjuster issues. The title is What You Never Knew About Claims Handling, and I will get to that in a moment. Special thanks also to my consulting group of JCCs, Judge Jeff Jacobs, Lourdes Sancerni and Eric Grindle, who, by the way, has volunteered to be a moderator for our next program, which addresses expert witnesses and doctors' depositions. So you don't want to miss that. I believe that will be April 17. It's a Friday, noontime, same time. Also, special thanks to uh, the, our partnership with WCCP. Uh, Stacy Hosman and Tanya Griffin for getting the word out to all the claims professionals and seeking CEU credit from them. So this is a combined partnership in order to provide you guys with quality programs that deal with day-to-day practice issues, not the stuff that you probably won't get at other CLEs. It's the what we do on a day-to-day basis from the beginning of uh, the the claimant interview to the phone call that the defense lawyers get from their clients saying, should we pick up this situation or controvert or do a 120 to all the other issues that are involved in litigation, including pre-trials, trial prep, motions for rehearing, even making sure that you've preserved all your issues for appeal. So we hope that this is a valuable program for you all. There's no charge. You get CLE credit. And with that, let me introduce Rick Thompson is what started out as a defense lawyer, became a claimant lawyer, then was appointed JCC in Orlando. He is now vice president of claims legal with Zenith Insurance Company. He basically monitors and and assists all of his in-house and out-house attorneys throughout the country. Gina Jacobs was started out as a an adjuster, and she is now managing partner of the Orlando workers' comp unit for Hamilton, Miller, and Bertisel. And Christine German is vice president of casualty claims for Brown and Brown. So, Rick, take it over.
Thank you, Stuart. I appreciate the opportunity to speak into y'all. And I tell you, it gives me life when I see names I've not met before. After the reforms of '03, we had a dead zone where we didn't have new people coming into the industry. And now I'm very pleased to see that we're back alive again and doing well. Uh, I don't know if I qualify as a virtuoso. I had to look up what it was, in fact, but I do appreciate the invite just the same. The three of us come from different backgrounds and have different perspectives. And I think that what we're hoping to achieve today is to tell you the stuff that's not in the rules of procedure, the statute, or the case law, and give you some practical tips and understand where the other parties are coming from. And this should help you in your everyday practice. We're going to start with Christine, who's kind of a dual threat. She understands the claims aspect of things in her background, but she also now works for one of the largest agencies in the state of Florida. So she has a different perspective. And we're going to start out at the very beginning of what is done when a claim comes in, especially a serious claim. How is it set up? What is the claims department doing? What is the agency's involvement in that? And with that, Christine, I will kick it over to you.
Thanks so much for having me. So when we talk about claims coming in the door and what's required, I do want to start with saying that adjusters have a really big job. And I believe that the quality of a claim is really determined in that first 24 to 48 hours of a claim coming in and what they're doing with it. So when we talk about early investigation of a claim, or you hear a reference 3-point contact, that's our first go at touching and handling the claim and establishing some sort of relationship or rapport with not only the employer contact, but the injured worker and the medical provider who's charged with managing that claim. So as much detail as possible, we're looking for them to obtain. Aside from how the injury occurred, I really want to know what a person's background is. and what their, needs are from a holistic perspective, because that really helps us to manage the claim long term. So, superficial first contact to me leads to just downstream issues, reserve instability, more litigation risk. So, the depth of their initial reach out truly matters. And that thorough investigation sets the foundation for everything that's going to follow for them. When we talk about establishing rapport with the key stakeholders, really, it's not even a soft skill. It's really an operational strategy that they have to employ. Otherwise, they're not going to be successful long term with how that claim is managed. I think that if adjusters take that initial conversation with an injured worker and really be the listening ear, tell them what their expectations should be of the claim, what their role is in the claim, show that care and compassion. An injured worker is going to be much more receptive to their involvement. And when I sat at a desk level, so I understand the challenges of day to day adjusting. But from the perspective I sit now, we're really looking at how a client manages their overall program and is able to control their total cost of risk. And that really is impacted by the day to day activities of an adjuster and what happens at that desk level. When we are dealing with issues later on in the claim, a lot of times those issues could have been resolved from early intervention or early conversations that should have taken place. In Florida, I think we are blessed to be able to have a lot of control in claims that we don't necessarily have in other jurisdictions. But because there is that control, I think it also leads to a lot of issues that arise down, a couple months into the claim. And if we can start to predict what those issues might be earlier, I think we have better outcomes. So I like to tell our adjusters who are working our program, get to know the people that you are managing the claim for. Get to know them as a human being. What does their home life look like? What needs might they need in the claim? And just because the statute doesn't provide for something doesn't mean we can't show care, concern, compassion when dealing with them. So I think it overall helps to reduce fear and misinformation. As the claim progresses, it improves cooperation, and it really helps to anchor that claim transparency from day one. So, I've been asked to explain a little bit of the claim process. When we walk an employee through that claim process step by step, and set those realistic expectations about not only their treatment needs, but the benefits that are provided under workers' compensation and the timeline for which they can expect those benefits, will ultimately help reduce the anxiety that often drives a lot of unnecessary litigation. And avoiding or preventing those misunderstandings really helps to avoid a lot of disputes later on. So overall, the 3-point contact, that early investigation, I want it to be more of a just check the box activity. It's quality over, the initial just reach out. So when we talk about reserving, a lot of times, that's the piece that really not everyone understands. Getting it accurate is almost, it's not an exact science, is what I'm trying to say. It's a best guess of what's happening. And it really depends on the facts that you have and the solid understanding of the medical picture that an adjuster is able to secure. So a good reserving, situation would represent an accurate assessment of the realistic view of that exposure. Sometimes adjusters have an inflated, reserve. That's where it's overstated. The total cost of risk is inflated from what it should be. And sometimes it's too low. And that creates surprises when, increases hit. So I guess I should take a step back and say that reserves for an adjuster and for an employer organization really represent the expected total cost of that claim. And when a reserve is set, that appears in their total incurred. And when they're looking at their program, that directly influences how the claim shows up on ultimately a loss run and what people are going to be prepared for in the future. So I think something to point out, reserves are not just an internal number. They really affect, budgeting, premiums, long-term risk strategy. And when we don't have the preparation needed at the front end, that makes things difficult on the back end, especially when we start to talk about things like litigation and mediation. But I will stop there, Rick, because I know, that gets into litigation, mitigation strategies that you were going to pick up.
Right. And what you said dovetails nicely into that. I know I call myself the civil of workers' comp because I've had so many different careers in this industry. And harkening back to my years as a claimant lawyer, the number one reason why they would come to me was lack of communication from the adjuster. It wasn't that they thought they were getting screwed over, they just weren't hearing back at all. And then now I hear from the employer side where why they buy insurance from one company versus another, it's also communication. They get frustrated because their employees are not getting physical therapy. So I think you hit the nail on the head with the number one way to mitigate litigation. But let me diverge a little bit from that and talk about the stuff that's not in the manuals. Um, I think it's important to have a good perspective or context of where we as adjusters, attorneys, and judges fit in the system. When I came to work for a carrier, I had been a claimant lawyer, a defense lawyer, and a judge, and I thought I knew pretty much everything about workers' comp. I thought that what I'd been doing for all those years was all what workers' comp is all about. And I quickly learned that I knew something about 10% of the industry and absolutely nothing about 90%. And I'll pass along to you what I've learned. And I would encourage you, I'm going to give a shameless plug for a panel I'm moderating at the Work Comp Forum next month. We are doing a panel on Insurance 101 to explain to claimant lawyers, even examiners, and certainly defense lawyers, the bigger picture. And what I mean by that is, I looked at our internal numbers, and I believe they are reflective of the industry as a whole. For every one lost time claim, that's where lost wages are being paid, we have 3 medical only claims. So 25% are where people lose time from work. So 75% of the times that people are hurt on the job, and I understand they're the less severe injuries, we're talking lacerations, sprains, they don't go to lawyers, they don't get litigated, they get treatment, they get patched up, they go back to work, and the claim closes. That's 75% of the claims. Of the 25% where people miss time from work, 25% of those get litigated. So if you do the math, and I don't do math well because I went to law school to avoid it, but I had someone help me out, a little over 6% of injuries end up in our world. So we are dealing with a very, very small subset of what goes on out there. Now, we all understand that what we deal with costs the insurance companies and the people paying the premiums a lot more than those MO claims. So we play a very, very important role in it, but it is a very small role. Our system works for the most part. And I know Judge Langham is on, and this is not, he's heard me say this before, and I put my hand on the Bible to say it again. I have played extensively in 28 states in this country, and we have by far the best adjudicatory system in the country. It's the quickest, the fairest, most efficient, most professional, and we have the best bar and level of examiners in the country by far. The second best is way behind. So you have something to be proud of and to be want to be a part of. We do it very well here, and that kind of rolls into the litigation mitigation aspect of it. Um, you know, there are bad actors on both sides of the equation. I would estimate it maybe 5% claimant lawyers are bad for the system, and 5% defense lawyers. I think we have some claimant lawyers that drum up frivolous litigation, and we have defense lawyers that drum up frivolous defenses to bill hours. It's all about the money. But I think 90% of us are doing things for the right reason. And I read a case that came out, I believe, yesterday from the First District Court of Appeal that is a perfect example of why we have a place in the system. It was an attendant care case with someone, I believe they were quadriplegic. The issue is whether, when that person wants to go visit family in New York, whether the carrier has to pay for all expenses with bringing the attendants and equipment so they could visit their family. And as a human being and as a lawyer, I could argue both sides of that equation. The court came down and said, no, it's not medically necessary, so they don't have to pay. But I could argue that both ways. That's a perfect example of why we need lawyers. And I'm a pro-lawyer person that works for a carrier. I believe we have a legitimate spot. We just got to get rid of the unnecessary litigation so we run more efficiently, because litigation is very expensive. You get into IMEs, you get into paying lawyers, you get into paying mediators. It can really put unnecessary pressure on the money that should be going to the injured workers. But overall, I think, Christine, you nailed it. It's communication, it's treating people with respect. I look at our universe, and the most seriously injured people, they typically are represented by the most experienced lawyers, and I see very little litigation. I understand why people that are severely hurt get lawyers. I would encourage my family member to get a lawyer. You need to know everything. But those cases we find that are with our best examiners and are with the best lawyers, they don't really litigate very much. They talk on this thing called the telephone, and they work through the process and identify there might be little disagreements on how far the benefit should go, but they work things out. That's not where the problem is. The skirmishes seem to be on the lower dollar cases. So I encourage claimant lawyers to pick up the phone and try to establish a rapport with the examiner where y'all could work together. I know there are examiners that will not be responsive and that you have to file a petition. I understand it. I get it. You have to do that. Also, examiners, I know you may reach out to some lawyers and they're unpleasant or won't talk. I get that too. But always give the person the benefit of the doubt to try to work it out. That's always the first step. We are blessed to live in a state that is high growth. I can assure everyone on the phone there's going to be plenty of work for you to do in this industry. You don't need to make up reasons to litigate and make a living. So the other thing I want to say, and I would say that this is something that will be prevalent when I'm long gone and retired, and I'm not so sure that's the case. Premiums in Florida are down 80%, and that puts a lot of pressure on carriers to lower their expenses and to do more with less. And we've had the advent of AI, and I know we hear about that in the news every day, and it's becoming somewhat prevalent in the insurance industry. Carriers are having to become more efficient and have machines do the work that people used to do. There's been legislation proposed in Florida to limit the use of AI in claims examining. I think that that's the right thing to do. Whether it should be done at the state or federal level is another question. But personally, I'm okay with a machine saying yes. I have a problem with a machine saying no. I think there needs to be a person that signs off on a denial of a benefit that can be held accountable. I can't imagine a day when a claimant lawyer is having to depose a chat bot and how that will go. But things are changing, and we all need to keep up pace with this and think of how we're going to deal with it. With that, I'm going to pass it over to Gina Jacobs, who is a very dynamic defense lawyer, and have her give her perspective on how you partner with the carrier to make things run smoothly. Gina?
Thank you very much, Rick, and good afternoon, everyone. So I was asked to provide, kind of some best practices when it comes to cultivating a relationship with your defense counsel. So in essence, what is it that can be done as defense counsel representing the employer, the carrier, self-insured, to make sure that that process goes smoothly and consistent with Christine's statements and Rick, communication, communication, communication. Oftentimes when I meet a new client, that's essentially the grievance as to why they're pivoting and looking for new counsel. And given AI has obviously given carriers new tools. So we are being analytically monitored as far as our efficiency. We are being analytically monitored for responses. And technology is great because it's going to help us do our jobs a lot faster. But then the downside of that is the response time has to be consistent with your customer's expectation. And, it's not like the old days when a client used to ask for a status report, we could dictate it, wait for the dictation to come back, do the corrections and all those sorts of things. And essentially, when a client's asking for a report, maybe you had a week or so to get that out. Now it's on demand. So if a customer is sending an email, there's that expectation that by close of business or the next business day, they're going to get a response. And one of the things that I have personally tried to do, to better help the customer, but also for selfish reasons, is if there's too many emails going back and forth regarding a specific case, we have the ability now to jump on Teams and have a meeting and have everybody and all the relevant stakeholders provide, their questions, and you can roundtable the case. And so I know a lot of defense attorneys haven't really cracked into that, but that's the direction that things are going. And that's actually what carriers, as well as employers, are looking for. They want very clear instructions on what the recommendations are being provided. They want a very clear position as far as your recommendations are on a case. And there is such a thing as maybe you need more information in order to provide that opinion. But another common thread of what I'm hearing is my defense attorney says I need to go to trial. It's not clear as to why I need to go to trial. I don't really understand what my alternative options are. And so if we're not providing that customer with a very clear indication of what your opinions are, what your suggestions are, then how is Christine and Rick going to make that good business decision from a cost benefit analysis standpoint, because it's their responsibility to reduce the average spend as well as the shelf life of the claim. And if the defense attorney is not clear on exposure analysis, for example, how is the customer supposed to know? So back when I was an adjuster, the thing that I hated to see was the initial case evaluation that was 1 page long and said, you're going to need $150,000 to settle this case. And there was no suggestion on discovery. There really wasn't a breakdown as to how the lawyer came up with that $150,000. So communication, if you have a settlement recommendation, it needs to clearly articulate for the client where those numbers are coming from and what those cost drivers are. Now we're seeing a lot of examiners that have entered this industry that do not have experience. And we are having on the defense side to do a little bit more training and education and sometimes handholding. And so if we're not providing that examiner with a very clear instruction, then you're not fostering that relationship. So, you want to see it as a partnership. I'm not here on the file as attorney of record for the employer carrier just to call me if you need me. As defense counsel, I need to be proactive forecasting what this claim is going to look like 6 months down the road, 12 months down the road. So it's critical that in that partnership, you are forecasting and then clearly articulating what those things are. Again, I think many of us that are defense attorneys, we've got adjusters that either just got their license like last week Tuesday, or they've only been doing it for a handful of years. And now all of a sudden, this is an examiner that is a senior examiner. We also know that on the carrier side, something that Rick brought up earlier is that if you've got a complex claim, as a part of that claims triage process, that's going to be sent to a very seasoned examiner. However, the trend now is clients want a dedicated adjuster handling all of their files for one specific state. So you may have an adjuster that only has 1 year of experience that has, your basic trip and fall claim, but also handling a permanent total or CAT case. And as defense counsel, it is critical that when you know that you've got an examiner that does not have a lot of experience, very clear instructions on expectations or recommendations, I should say, should be in your reports and in your correspondence and in your meetings. You should be, taking a consistent position. And then if there is an exposure change of some sort, you need to clearly and timely articulate what that is. So, if you go to a claimant deposition and you learn some information that has now changed that exposure, so maybe in the beginning you were projecting that the value of the claim was going to be X, but now it's Y, you need to timely state what that is. So if I'm fostering a good partnership, Rick works for a publicly traded company. So if there's going to be an exposure change, he's got, shareholders that want to make sure that the losses on the books at Zenith Insurance are clearly stated. So you don't want to be defense counsel not forecasting these things timely, and then now all of a sudden we have to do this massive reserve change, because then that becomes an issue as well. I think as a part of communication is, when you have a customer, is to understand the nature of their business. I'm a big fan of the site visit, and that having a meeting to say, hey, explain to me how your business runs. I may know your business as a big box store that I went and bought a mattress at. However, I may not understand the inner workings of your business and how risk management interacts with other departments. Because if I get a case, I really want to imagine essentially where the accident occurred. I want to imagine, what types of information that I should be asking for, as opposed to just looking at the notice of injury and the mechanism of injury in a vacuum. You're not really getting the whole picture. Again, we've got technology that the carriers are able to utilize. And along those lines, we want to make sure that we understand what our client needs. So you have one client that may need less communication from you, and you may have another client that needs more communication. Whatever that cadence is, it's important to establish those things on the front end of the relationship. I think it's also important as well that clients understand at some point, I might want to take a day off. I don't want to work 7 days a week. But if you set those expectations up in advance, hey, client, if I happen to be unavailable, here's my colleagues back at the office. You want to have even a buddy system within your own firm. And we understand how it goes as far as, your clients and, wanting to be in a position to safeguard those relationships. But I think it's necessary for a successful practice, and it's healthy. But, we condition people how to treat us. So if we are fostering a partnership, we want to be very clear as far as essentially how I do business, and I want to make sure that I am able to modify that around my client's needs. Again, wherever feasible, I think it's important to have that FaceTime. And now that we have Zoom and Teams, it's so much easier now to have a roundtable instead of having to, back in the day, schedule a meeting, find conference space, get in the car and go. Sometimes we're just so busy that actually the in-person is very difficult. But I can get so much accomplished. I can have several Teams meetings a day, and, we've done action plans. We've, assigned tasks to different people, but it's very important that after you have that meeting, you send the confirmation email or correspondence identifying who is doing what. Oftentimes meetings happen and no one has really documented who is going to do what. And then, 6 months down the road, there were things that were discussed, action plans that were developed, and things that were not followed up on. So communication and very clear instruction. I think as practitioners, it's also important to document what your opinions are, because let's just say you've got a newer adjuster. You made a recommendation to do X, but the adjuster said Y, and it wasn't documented. And now, because the adjuster took the wrong position and the situation has now catastrophically blown up, you don't want to be the person trying to explain that's not what I told the adjuster to do.
I'm in a meeting.
Yep.
No, sorry.
Hello?
To input here, because you brought up a really great point about, the state of our industry and everything that transpired post Great Resignation, right? And the partnership that you're building. A lot of times, defense attorneys, number one, want to set up that relationship with the adjuster, make sure they have like a copacetic working relationship and that, files are coming in. But if there's something happening, I can speak from the perspective of being in operations at a third-party administrator. If there's something the adjuster is not doing, not following up on, or maybe they're being overly aggressive on a position, being able to bring that up to leadership perspective and say, hey, you might want to take an extra look at this is really important to the overall partnership that we have on a grander scheme than just that one claim and that adjuster. bringing us into the picture to say, hey, let's relook at this. And oftentimes, what's in the statute, what you can read as a benefit may not necessarily be what we need to do moving forward. We need to talk about what case law says. We need to talk about the practical business decisions that we need to make based on what's being requested of us, even if it's not black and white in the statute.
Let me throw
Absolutely.
another question.
Oh, sorry.
Go ahead, Gina, please.
No, and I was just going to say to Christine's point, we're in a season of a lot of movement. So maybe it's adjusters moving around from company to company, or, an employer that's going from one carrier to TPA and vice versa. It's been a lot of movement. I've never seen, this much movement in a very long time. And so it does make it very difficult. But to Christine's point, it's making sure that you understand the 360 of who's involved, to better know what they need and how to deliver that.
Well, let me throw a curveball in here for the benefit of the younger lawyers on the phone. And you ladies might not ever talk to me again once I throw this out there, but I hope that's not the case. We talk about partnership. We have a unique relationship in workers' comp in that the defense lawyer represents in Florida both the employer and the carrier. In some states, they only represent the carrier. So it's very easy. The employer is really not a party to it. The carrier buys all the liability, pays all the bills, pays all the benefits. In Florida, you represent two. And I know in some cases, I have the employer in conflict with what my examiner wants to do. And in my case, I have a mantra: when in doubt, send it out. And that means if I smell a conflict between the employer and the carrier, I send and get them separate lawyers to represent their interests. Although the contract of insurance gives the carrier and the examiner the final say on what's done with the claim, despite the employer's objections. Gina, how do you deal with situations where you've got your two clients at odds with each other?
Right.
I mean, that's awkward communication there.
Right. And those are things that sometimes start to percolate over email. And then I'm a fan of, hey, let's kind of get everybody to talk it out, because in essence, most times when you're getting that resistance from your insured, it's because of lack of knowledge or understanding. And what I like to do is talk about the case law. What I like to do is pull an order from that judge on a very similar issue to say, listen, I've surveyed these orders, and essentially this is what this issue could potentially look like. And I feel that once the employer, has more information, they're in a better, stance to potentially be aligned once they understand, because sometimes it's just a dollar objection. I don't want to pay this, or I can't afford this. But then once they realize, well, if I pay this in today's dollars, but in 6 months, you're going to be asking me for 3 times as much. That's essentially what it is. It's really just lack of understanding. So yes, it does start that way. I'll submit a deposition summary, I'll write everything out. And I can always tell where the resistance is. And once you have that meeting and you talk about it, you go over the case law, you essentially identify how that issue may potentially turn out at trial. That most times cures it.
And
Christine, how
also,
does the agent deal with that? I mean, you're advocating on behalf of the insured, yet you're appointed by the carrier, kind of in the middle. How do you handle it?
yeah, so, I work on our claim advocacy side of the brokerage, and really that's what we're there for, like to be that voice of reason, because a lot of the time the employer or, the insured is looking at it from a very financial, small financial picture. And we have to come in and say, listen, this is what it will look like. This is what it could be. This is where I think you should go. And just be that. A great partnership isn't me telling you everything you want to hear. That is never going to be, it's never going to work out good for any of us. My job is to tell you what's necessary and to get us to move in the right direction that's going to impact you positively later on down the road. And if you can trust that I'm going to have, the global best interest, then I'm going to get the employer on board. And if Gina brings me into it, she knows, from our working relationship that I have that understanding and I can get us where, if we have a united front, we're going to be able to bring the employer in and get them where they need to be as well.
That's great. We have 5 minutes left, and we have a really important topic I want to get out there is how to prepare for mediation. And I'll put in my 2 cents. drives me nuts when lawyers go in and play these things off and have not prepared, and it's a waste of time, especially on a bigger case. And I would just advocate, whether regardless of what side of the ball you're on, look at the issues, identify the blocks to getting the case settled. If there's a child support issue, figure it out beforehand. If there's an MSA issue, figure it out beforehand. If there's a personal issue, a divorce, and worried about the money going to the soon-to-be ex-spouse, figure it out. And the one thing I will say is, a claimant lawyer that comes in with an astronomically high demand without any substantiation of why it's there has no credibility. And I say this to our lawyers too: show your work like an elementary school. If you're going to come in with a $250,000 demand, tell me how it's broken down and how you got there. When you show your work, you come in with legitimacy, and you're much more, and a lot of times it'll open up the carrier's eyes and say, I missed that part of it. You're right, and you'll get more money. With that, I'm going to be quiet and turn it over to Christine and Gina.
I think that preparation for mediation starts at the very moment that initial PFB is filed and what it's asking for. Because number one, there might be some things on there that we could easily resolve with phone calls. And I agree with you, Rick. These days, it's hard to get everyone to pick up the phone and connect like that, but it's beneficial. But if we're moving to mediation on issues, we should see a demand at least, 60 to maybe 45 days out. That gives the adjuster some time to present their case for what they need in authority. And a lot of times, the adjusters don't have authority right then and there. They need to write up a case summary, even if they're dealing with the carrier side. They need to write up a case summary, make it make sense, and get somebody's buy-in. If we're going to a client asking for authority, they might need to get, somebody in the financial department squared away on whether or not it's okay and we can do it. So the most productive mediation is going to be where we come together in advance and state our position. So claimant counsel, if you can have that in soon enough that you can potentially state your position and get us to evaluate that and start putting some numbers to it, it's going to be a more impactful, meaningful mediation, if that's the goal.
Absolutely. And I think one of the things that is tricky is, again, when we get that petition and it's time to set the claimant for deposition, whether the adjuster goes first or the claimant goes first, and all these little, things that we have to deal with just to get the depo on the calendar. You're not really helping yourself if you want us to take the claimant's deposition a day before the mediation. To Christine's point, we have to write up a report. Then the adjuster has to separately write up a report. And depending on how much money we're asking for, we may have to get concurrence from 3 or 4 different people, because the first contact may have 25,000 and the next one has the additional 25,000. And the person at the very top does not see it until everyone down below cosigns. And let's not assume that the day that we ask, everybody's sitting at their chairs waiting for us to request settlement authority. So it's really more helpful if we can, get that deposition out of the way so we can write our report and request the authority. And, the trend right now is we're seeing a lot of these businesses now have in-house attorneys that are going alongside the claims team, going alongside the broker. So sometimes when I'm having these team meetings requesting settlement authority, there's a lot of people involved, because again, there's different layers of authority. Help me help you. If there is legitimate interest in getting the case settled, let me know in advance. Let's get the deposition out of the way. Because sometimes I think, these files where you're just going back and forth trying to get the deposition on the calendar, and then you're saying, well, hey, let's just settle it. I can't just get money. The money doesn't grow on trees. And for these businesses, even though insurance rates are down, the cost of claims has gone up. So that's why we're seeing these brokers and other, in-house folks that are, that actually work for the employer that are involved, because it's all a part of cost containment. And obviously, if we need a certain amount of money to get the claim settled, I cannot call my client and say, hey, I've got mediation tomorrow. Can you give me $100,000? It's just not going to happen. So we don't like the recesses and reconvenes. We don't like having to go to mediation, essentially not knowing. But if there is a very large, if it's a high exposure, a high demand should not surprise me. So I'm already forecasting that, and I'm already communicating that out to my client. However, suppose there's a new development, a new diagnosis that's changing the exposure. Let me know ahead of time where you are so we can have that conversation. And last but not least, when it comes to the issue of Medicare set-asides, these are the vein of my existence right now because it just seems that it's taking too long to get these done. And so if we know that we've got a mediation target date, how can I, as a defense attorney, go alongside my adjuster to make sure that they have the medical records, they have the medical bills, so we can expedite getting these things timely? Because I can't request that settlement authority until I know how much that MSA is. I can't just say, maybe experience is telling me it's a $100,000 case, but suppose that MSA comes back at $100,000. So
Yep.
help your
All good
clients.
points. All good points. I can feel Stuart's hook getting around my neck right now as we approach the 1 o'clock hour.
Well,
Stuart, is our time up?
yeah, not necessarily, but I do have a question for the group, and that is to what extent do these demands in advance impact on your reserves? In other words, are reserves static or are they dynamic in that they can change from the beginning of the case to the end of the case? And might a demand and a good assessment letter in advance have some impact on the reserves, making it more likely that you can get a case settled?
That's a great question, Stuart. Reserves are ever changing. As the story evolves and the story changes, so should our evaluation of reserves. So that early case assessment, I can only reserve for what I know its potential at that time. So as things progress, as treatment progresses, as we know more about their needs, maybe they're surgical, those reserves should be changing. And if the adjuster is on top of things as they should be, that reserve should already tell a story long before the day we're at mediation or long before the 15 days prior to mediation. And if the reserves are set appropriately, everyone already knows the potential value. And so settling shouldn't be as much of a difficulty, or getting the authority shouldn't be so much of a difficulty because those reserves are already in place. What really impacts things, Stuart, is when last minute things come up right before mediation. Maybe they just went back to the doctor. Now they're surgical where they weren't, at the time we were initially preparing. And so changes like that happen. But when we know about things in advance and we're not prepared for the potential, that's when we get a lot of hang up in reserve or in settlement authority because the reserves aren't even set for what that potential exposure looks like.
I would say it's rare, and maybe it's just my company because I think our examiners do a phenomenal job of reserving. But I have seen a good demand letter from a claimant lawyer change the reserves and have more money ready going in mediation. It absolutely can handle. So I'm a big fan of preparation. And I've also become a big fan of reconvening. I know that the examiners I work for would slit my throat if I said that. They don't like it. They like to get it done the first time around and don't leave anything hanging. But on a bigger case with complexities, sometimes you're just talking through the barriers to settlement at the first mediation. Go and do your homework, come back ready to talk the second one.
Rick and
Well,
Christine, question. Because you guys deal with the one-on-one with employers more than I think Gina does. Do you ever have workshops with uh, with employers? I think every claimant lawyer will tell you countless stories of clients that say the reason why they got to a lawyer is because they were treated disrespectfully. The employer said, "You didn't get hurt on my job. Get off my premises. My premiums are going to go up." And I even had 30 years ago when I was claimant lawyer. I remember having a client who had been with his employer for 38 years. And he said the reason why he came to me was he went into the hospital for surgery, and he said nobody from his employer stopped by, called, sent a card, sent flowers, said anything about the fact that he was injured and was now suffering from surgery. To what extent do you guys reach out to talk about the impact of that respect of claimants when they do claim that they have an injury.
Well, Stuart, I'll tell you that really I should have brought that up in the litigation mitigation section. Is critical. Um, if we find an insured that treats people like that, that always leads to much worse outcomes, and we will not renew that account. It's just too risky. They will take a small case and blow it up into a big one. And we preach that to them, that just because someone gets hurt doesn't mean they're a fraud. You have to treat them with respect and give them the benefit of the doubt from the very beginning. And we find our most successful employers take that seriously, have real return to work programs, and make the workplace such that people would feel guilty suing them. That's your perfect employer.
And we do educate a lot. Anytime we see a potential issue, we take the opportunity to educate our clients. But I also do a lot of project work with large organizations. I'm in one now where I evaluate their entire operation, how different departments are communicating, what communication they send out to employees about workers' compensation and how to report an injury, and toolkits that are available once an injury is reported. And one thing we focus on the most in these operational assessments is employee well-being. And that is separate from how the workers' compensation is going to progress. A lot of times they file a claim and go, oh, the corporate work comp contact is in charge of workers' compensation. That corporate contact has no connection to the day-to-day employee relationship. So training our employers that if they continue to keep that relationship open, care and concern going to the employee, asking them how they're doing, asking them what they can do to help them, advocate for them differently. All of those things are very important to the overall outcomes of their entire program.
Well, I think unless you guys have any closing points, do you have any closing points, Gina, Rick, or Christine?
Communicate, communicate, communicate. That's really the name of the game, and it's not just with your client, but obviously on the other side of the V, to Rick and Christine's point. But thanks again, everybody, for attending today.
Thank
Well,
you,
thanks.
guys. And Judge, are you out there? Do you have the CLE number? There it is. Thank you. I can't see. There it is.
You see it?
Yes. 26.
And while everybody's copying that down, my apologies again for the late start today. That was entirely my mistake and my distraction. And it's inexcusable to be late like that and held everybody up. I'm sorry.
You're forgiven this time. Just kidding. Everyone, thank you for your
Thank you.
indulgence. And thank you, panel. You were terrific.
Thank you for
Thanks,
having
Everybody
us.
have
everybody.
a good weekend.
Yes. Bye-bye.
Bye-bye.
Judge, thank you
No, thank
again.
you, Stuart. I'm going to leave this up for a few minutes till we see folks log off. And there may be some folks who are still copying the numbers down. So I'm going to leave it
Oh,
open, but
one other thing. Yeah, Tanya says send your affidavits or communicate with Tanya Griffin over at Hossman Associates with regard to getting your CEUs.
so the participant count is slowly going down. Some folks may have stepped away for grabbing a bite to eat or refilling their coffee or whatever. I'm going to leave it up for about another minute and then we'll shut it down.
Roughly how many people attended?
At your peak, you had just under 60,
Hmm.
and it's dropping off now slowly. Um, I think that this topic is not something that people inherently note the value in, but the people that want to resolve cases could have learned an awful lot today.
I
Uh,
totally agree.
and you know, one of the things that was a corollary, but we were short of time. One of the speakers mentioned, if you're going to come in with a $250,000 demand, you need to be able to justify it. And people forget that the corollary is true also. If you're going to come in and offer $2,000, you need to be able to justify that. Why are you offering zero? Show your work. Um, I don't understand why folks don't communicate better in preparing for the negotiations.
You're preaching to the choir.
I know, but the choir's all that's left. Everybody else
Yeah.
has left the church. That's what,
Yes, 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 yes. Yes. Yeah. And like another corollary is that uh, containing expectations is critical, for on both sides. From a defense attorney, you don't want to understate the value of the case just because you think that's what your client wants to hear. Or on the claimant side, it's very risky to be talking about numbers that are not achievable. Uh, Claimants don't understand that. They believe that the numbers that claimant lawyers start out with are, not just um, the correct number, but they're probably too low. And so you're not doing your clients any favors by either overstating the value or understating the value.
yeah, and not taking the time on both sides of the table to explain it to the client before you're in the meeting.
Exactly.
Spend the time, the
Yeah,
planning. Wow.
definitely.
So that's been another 2 minutes. Everybody's had their chance. I'm going to shut it down and we'll be back in touch. Thank you,
Wonderful.
Stuart.